Good morning, everyone. Good afternoon, wherever you are. Thank you so much for joining us on this webinar, which is a really special one for us at the Sabin Center because we're launching a big report that we did on just transition in litigation in Latin America. So I'm Antonia Tigre. I'm the Global Climate Litigation Fellow here at the Sabin Center at Columbia Law School. And I'm just going to show you one slide to explain a little bit about the context of what sort of how this came about, and then we'll move on to some of the content. So I hope everyone can see the slides, but so this webinar today is going to be focusing on just transition in Latin America. A group of 6 of us, we wrote this report focused on the Latin American cases in this really innovative area within climate litigation. And just so you sort of understand how this came about, so about a year ago, the Sabin Center created a network of peer review scholars on climate litigation. Which basically means that we have volunteers all over the world who represent a jurisdiction or a certain court, international court or tribunal or a quasi-judicial body, and they basically help us maintain our database on climate change litigation by letting us know what is happening in their own jurisdictions. It's been a really incredible project, which I lead. I manage the Sabin Center's database and manage the network. We started with about 20-something volunteers. We now have over 100 scholars and litigators throughout the world, covering 74 jurisdictions and 17 international or regional adjudicatory bodies, which is really incredible. And part of that is that part of this work is that obviously they let us know about any updates, but we also have monthly meetings in which we discuss general trends within climate litigation and then create research groups whenever there's a specific topic that some of our rapporteurs are very interested in engaging further with. So that's how this particular group started. We created about, I think maybe 9 months ago or a little over that, this working group on just transition litigation, which some other scholars had identified as a leading new area, innovative area within that field. And we decided to basically investigate this a little bit more. And because of the makeup of our group, and we decided to focus in terms of the case that we found, we decided to focus on Latin America first to see how that is developing within that region. And hopefully either this group or somebody else can sort of expand that into other areas as well. So we're very fortunate to have with us today to be sort of our keynote speaker, Gladys Martínez from AIDA. AIDA has been very supportive of this project and a wonderful partner as well. And they are translating this report into Spanish, which will be really incredible. So that will be available and shared very soon. And so I'll lead over to Gladys now. I'm gonna put her slides here on, but we're very, very grateful to have Gladys sort of kick us off.
Thank you so much, Maria Antonia. Thank you so much for the invitation. It's an honor to share this virtual table with the brilliant experts that wrote this report. That it's going to be very helpful. Thank you. So while you show my slides,
I think they're showing, right?
I cannot see them, but if you see, we can start. Yesterday we had a minor earthquake in Costa Rica, so our connection is very slow. So maybe it's a problem in my end, and I'm gonna try to have the camera on all the time, but I do apologize if for any reasons the voice gets slow. I will turn it off, but I'm here. So if we can go to the second slide, please. I just wanted to first introduce AIDA, which is a regional organization that uses the law and science to protect the right to a healthy environment in Latin America and the Caribbean. This year, we're going to celebrate the 25th anniversary, so we are very excited on that too. And I cannot see the slide, but if you were seeing a picture of the team, I wanted to introduce my multidisciplinary team of 40 plus brilliant and creative and committed multidisciplinary professionals, that they are the ones that are using tools to achieve our mission, tools as litigation, as advocacy and diplomacy. And first, the Sabin Center that gladly invite me, and I'm honored on that. Now I can see it. Thank you, Antonia. Thank you so much. Asked me to do a little bit of background on Latin America. And I wanted to start by saying that Latin America is a region that is highly dependent on fossil fuels. And 88% this is the team that I was mentioning. And this was our last retreat in Costa Rica. So I just want very proud of the work that they do. So we can go to the next slide, please. And so Latin America is very, very dependent on fossil fuels, and 88% of the energy in the region comes from this source. So to maintain this local energy matrix of hydrocarbon producing countries have been extracting these resources in very high quantities. And this has generated a decrease in reserves. So at the same time, extraction of coal, gas, and oil in the region has caused serious environmental and social impacts in the territory which it has been produced. And from Mexico to Argentina, the footprint of impacts on human rights and impacts on ecosystems produced by this exploitation has been devastating. Additional from this specific reality, the climate crisis places the region as one of the most vulnerable in the world. And several countries are already experiencing the devastating impacts of climate change, and future projections, are not encouraging. So we have seen also a reality that in Latin America, authorities are promoting natural gas as a transition fuel and are promoting coal for domestic use and expansion of extractive frontier towards strategic minerals. So we have to take into account that these extractive communities include that these extractive actions include communities in the countries of the region. Many countries are betting on fracking as this bridge that I was saying, and to reduce dependence on other energy sources. But this technique is falsely presented as a step towards energy transition or as a transition itself. Therefore, this energy transition should be, in addition to changing just the energy matrix to renewable and clean sources, it should question an energy model that has demonstrated consequences and high environmental impacts. I will briefly mention 4 countries, and then at the end, I will mention some opportunities that we have and that we have seen successful and some needs. The 4 countries that I will briefly mention, because we have only 50 minutes, it's Argentina, Chile, Colombia, and Mexico. And it's based on a Just Transition report that we did. So if we can move, to the next slide, Antonia, thank you. You see here the Vaca Negra project in Argentina, and I will say that, for the case of Argentina, 53.1% of the country's greenhouse gas emissions come from the energy sector. And this is reflected in an energy matrix that is made up of 89% fossil fuels and 68% dependent on thermal generation linked to hydrocarbons. The government's long-term policy is associated with advancing the expansion of fossil fuels through fracking, offshore exploitation, and large associated infrastructure works. We can move please to the next slide. So this Vaca Negra field that we were seeing in the other side, it's affecting these Mapuche communities because 3,500 of these wells overlap with the Mapuche territory. And on several occasions, impacts from fracking activities have reported fires, explosion, leaks, pipe ruptures, and other loss of radioactive pellets. So, these damages caused to indigenous territory are especially serious because of the threatening of their cultural survival and of course affecting people and so key ecosystem like the Mendoza Rio. We can go to the other one, please. The next country that I will briefly mention is Chile. And in Chile, around 40% of the energy is produced from burning coal. And in 2019, the Chilean government announced a plan for voluntary retirement of coal power plants, which consisted of a scheduled shutdown the 28 existing coal-fired thermoelectric units in the country until the year 2040. This plan was welcomed by the community, but it was also criticized since it was based in a purely voluntary decision. And it was based at the discretion of the companies themselves. So it was really the question if it was a real closure or if it was not. So if we move to the same slide, to the next one, please. Thank you. And also, of course, we as civil society welcome that decision, and it opens the possibility of mainstreaming the use of gas, which is very worrisome, because according to the government, and recently the government of Argentina and Chile signed a collaboration agreement, and it basically facilitates the import of gas from Argentina to Chile. So therefore, in addition to the nonsense in abandoning one fossil fuel and becoming dependent on another, the possibility would give new and strength to the Vaca Negra in Argentina. And we can go to the next one, please. The next country that we wanted to mention, that we mentioned in that report, it's Colombia. And well, Colombia with this new government has shown commitment to make changes and to move forward. However, they still depend on coal and gas in its energy matrix, and by implementing thermoelectrical powers and developing oil and gas extraction through fracking. So there is at least some things to work on. And along with the problems associated with promoting these projects, in 2021, Colombia issued the Energy Transition Law, and it has raised many concerns among energy experts and civil society. That the law does not promote a roadmap to abandon dependence on coal and gas in compliance with the country's climate commitments. So on the contrary, it still promotes the extraction of gas through fracking. If we can move to the next slide, please. Thank you. Additionally, Colombia continues to have these significant coal reserves, and despite the climate impacts and socio-environmental conflicts produced during almost 4 decades of mineral extraction, the country does not contemplate serious plans that project a reduction of coal sector and processes the closure of mines. So still a work in progress. And well, as you might know, Colombia and Chile has requested an advisory opinion from the court on the impacts of climate change in human rights. So we seek to see the result of that, and of course to contribute with some comments and aspects. And we look forward to it with the Savings Center in the future too. So the next country will be Mexico, and I'll try to be a bit more quickly, but just to highlight that Mexico, in the case of Mexico, 70% of the electricity sector is based on fossil fuels, and mainly gas, fuel oil, and coal. So this sector emits 20% of the national green gas emissions. Mexico's current administration has promoted various changes to the energy policy and legislation, aiming and encouraging the use of fossil fuel in the energy matrix and limiting the production of renewable energy. Also, they have approved several unconventional deposits to public and private companies, which include the drilling and fracturing of wells in the coming year. Mexico has 3 coal-fired plants, and the main place that it's taking place, it's in the state of Coahuila. So yeah, there comes the question of sacrifice zones that we have seen in many countries in Latin America, like Chile and Mexico. And these mines have caused some violations of human rights, of labor rights, and serious questions on the impacts on health and affecting territories. With all this background and these few examples that I just mentioned, Latin America still has many opportunities and needs, and we can go to the other slide, please. And we have seen that throughout our 25 years of work in the region, and particularly in the last years, we have identified that we have seen advances when taking a regional approach. And by this, what we mean is that we set a regional focus, allowing us to see the forest and not only the trees. So for the just transition, we think that it can be achieved by working hand in hand at a regional level. As you saw, the decisions in Chile affect Argentina, for instance, with the input from Bacanera, etc. So we believe that taking regional approaches are key. Collaboration, of course, is essential. We know that the systemic changes that we want to achieve need a movement, and they will only be possible if many groups work together. And then litigation, which I expect that you will hear more from the experts in this panel, but litigation is key to achieve long terms when we don't see the appropriate changes. And in AIDA in 2020, we consolidated a climate litigation community of practice in Latin America and the Caribbean. And this has the aim to be a space for reflection and conversation around different experience around climate litigation. And we have seen how it has strengthened the capacity of different organizations in the region to implement more and better cases. Also, in this context of the community of practice, we have developed this climate litigation platform for the region, and we appreciate a lot the support from the Sabin Center again. And it has been a digital tool that contains updated and easily managed information, as a report that is here. And lastly, communications. Strong awareness allowed us and our partners to communicate the most important environmental discussion. We recently launched a communication strategy that is called Presentes, Hoy y Ahora, Presentes Today and Now, and it aimed at building a new regional narrative that promotes climate justice and just transition. So those are briefly some of the opportunities, and we can end with the last slide, please, Maria Antonia. Thank you so much. So with this, I just want to close saying that Latin America has enormous challenges, but enormous opportunities, and we seek to find a most fair, democratic, and transformative model to achieve this just transition, so that we allow, for instance, local communities as experts of the territory and ensure energy sovereignty as a right and overcome social inequalities. Thank you so much for the time, and thank you, Maria Antonia, for your help with the slides.
Thank you so much, Gladys. This was great to have as an introduction to our report now. So now move over to Marlies, who will explain a little bit of our methodology and some of the concepts that we use. and I'll have the slides for her here as well.
Thank you, Maria Antonia, and also thanks to Gladys for giving that context from the Latin American perspective. We will now move a little bit more into our report and what we have done. And different co-authors of the report will explain different parts of the report. I will start by explaining a little bit more detail, some of the conceptual underpinnings that went into selecting the cases and building the report. In terms of what does the concept of just transition mean, where does it come from, and how have we used it to actually curate this set of cases that we have been discussing in the report. We'll also tell a little bit more about the methodology, and then colleagues will go into depth on some of the categorizations that we have tried to do in this report by looking at, for example, which specific actors have been involved or which specific rights have been involved. But as I said, I will first explain a little bit about the conceptual underpinnings of the report and where we started. And I think we have drawn for the report, well, first of all, we've drawn on different research experiences of the different co-authors in the report who have been working on different parts of just transition or energy or climate or litigation in general and in the Latin American region specifically. So I think this different expertise or different perspectives have gone into the report, whereby we are also drawing on, let's say, 3 different types of developments that we can see in the literature and in practice that have helped us build, let's say, this definition of just transition and just transition litigation, and then translating it to the cases. So I think what has been important for us is to see that indeed this idea of just transition has been coming up from the bottom up initially already since a while, particularly from labor movements, social activist movements from the 1970s spanning until today. So I think this movement is very much a movement that is already owned also by people experiencing these struggles and asking for more just energy policies, climate policies, etc. But we also have seen that these struggles have been picked up in the literature, mostly non-legal literature since a while already, where people have studied issues like energy justice, climate justice, environmental justice, and have started to build this concept of just transition as a concept that spans these different fields of interest and study. And more recently, we see also non-legal literature emerging that is really targeting this just transition concept in much more detail. So it's trying to explain also its own meaning and how it has relevance for today and for the climate challenge that is ahead. We also see, and this is what we describe in the report, that this concept of just transition is then, perhaps not surprisingly, also making its way into international law and policy making, or regional law and policy making, or as we've seen before or heard before from Gladys, national policy making. There are a number of organizations which are particularly involved there. The International Labour Organization has been working on this since a while. Because of the strong labor movement dimension of the just transition concept. So they have actually set up guidelines on just transition already in 2015. But we've seen also the term just transition coming up in other contexts, such as the UN Framework Convention on Climate Change, where the Glasgow Climate Pact has indicated that they recognize a need for just transition, whatever this may perhaps means still in practice. The European Union very much refers to the just and inclusive transition that underpins its Green Deal, and with that also all its climate policies that derive from it. And we've also seen some movements in the Latin American region through the Organization of American States, but most specifically also the work of the Inter-American Commission on Human Rights and the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights. Whereby they have jointly supported this resolution at the end of 2021 on the climate emergency and human rights, where there is a dedicated section to the concept of just transition, and whereby they actually call upon states to implement their human rights obligations, including integrating labor rights and union rights as an integral part of that, when implementing and designing transition policies. So we very clearly see that there are different references emerging And maybe a last important one to mention is, because it has informed our definition in the end quite a lot, is a dedicated report on just transition from the UN Special Rapporteur on Extreme Poverty, which quite a few persons in our group had already come across and drew inspiration from 2020, where the Special Rapporteur particularly defines just transition, or let's say a human rights compliant just transition, as policies or projects that can capture a triple dividend, meaning that it will try to be good for the environment, create decent work and livelihoods, and also make sure that everybody has universal access to basic services. So let's say more the economic and social rights dimension. Then finally, we've seen in the last 2 years, I guess, specifically budding literature on the concept of just transition litigation that's now slowly upcoming, whereby there has been one paper by Annalisa Zavaresi and Joanna Setzer in 2020, where they had indeed identified that these cases are coming up as part of a broader trend of human rights-based climate litigation, but that perhaps there is no systematic data on these cases available yet. And we have seen a paper by Rafael Heffron that has tried to look at 100 cases in relation to energy transitions generally. He's a scholar that has worked a lot on energy justice and law already in the past, but perhaps this included both just transition cases and the more traditional climate cases. So our aim with this particular paper is to push this debate further and to also work with a systematic set of cases and try to unpack those and categorize those and really give some body to this concept of just transition litigation. That's maybe a good moment to go to our next slide. Because with this informing, let's say, our understanding of just transition and litigation in this area, the report develops 3 figures that try to explain our understanding of this concept based on the literature and the practice that has gone before us. And then this is the first figure where we stay close to the work of the UN Special Rapporteur on Extreme Poverty, which also closely aligns with what we see elsewhere in literature and in practice, is that just transition may be considered to have a three-part dimensions, whereby people may be concerned about issues of decent work, livelihoods, about having a clean, healthy, sustainable environment, but also having access equitably and adequately to universal goods and services. And in the report, we explain in some detail how each of these 3 dimensions is also very clearly underpinned substantively by human rights and human rights law, whether it's socioeconomic rights, whether it's the right to work or labor rights, or whether it's, for example, the right to a healthy and clean environment. And I think one of my colleagues will explain a little bit more about some of these different rights and how they are also invoked. Then for the second figure, and maybe we can move to the next slide. There's not just these substantive dimensions to the just transition concept, but maybe also these principles, these justice principles. Here we have also worked with the previous literature on energy justice, climate justice, where some of these principles have been discussed already since a longer time, not just the 3 principles on the screen here, distributive justice, procedural justice, and restorative justice, but also maybe recognition justice, cosmopolitan justice. But we have picked these 3 because, again, maybe they translate well to some type of recognized legal concepts or human rights that also some of my colleagues will explain a little bit more about. But the distributive justice concept would explain to this concept of fairly distributing burdens and benefits of the energy transition, which in law we may, for example, see reflected in this idea of intergenerational equity and intragenerational equity. There may be some procedural justice elements there in terms of how decisions are made. So is the right to information respected, public information respected? What about the principle of free, prior, and informed consent for indigenous peoples in particular? It's very important for the Latin American region as well. And then the concept of restorative justice and issues of rights to remedy. But I think, like I said, some of my colleagues will explain this in a little bit more detail. Then we have a final figure left, which is the figure on actors for the just transition. And I think here we've tried to just get a little bit of better sense and map out which are the actors involved in the just transition generally, but may also be involved in just transition litigation. And then at the top, we see workers, communities, indigenous communities, people as, I guess, the main beneficiaries. But to the right, also some other actors that are perhaps some of the most obvious ones: states, civil society, trade unions. We see future generation arguments coming up in climate litigation generally, but maybe also in the context of just litigation, just transition litigation. Companies, of course, and then maybe to the right, some actors that are still, we need to get some more insights on. For example, what's the position of nature, the rights of nature, Mother Earth? What are the roles of different types of courts and accountability bodies in this area? And also maybe what's the role of financial institutions, such as banks. But this was an attempt to sort of get an overview picture of what are these different actors that might be involved. With this background, let me introduce our definition of just transition litigation, which should be on the next slide, exactly. This definition builds on this research that I've just explained, but also certainly on the initial definition given of this concept in the paper by Savaresi and Setzer. And we've expanded on this by saying just transition litigation questions the distribution of burdens and benefits of transition policies. Oh, I'm not sure what happened. I think that was myself trying to remove something that was over the text. It questions the distribution of burden and benefits of transition policies and activities towards net zero emission and climate resilient societies amongst local communities and affected stakeholders. And I think with that first sentence, we would try to say that it's both about emissions limitations, so about mitigation, but also about adaptation, making societies climate resilient. And that it's about impacts of just transition, mostly on local communities, but maybe also broader affected stakeholders. Then the second part is that litigators typically invoke human rights, but they may also rely on other national and international laws and principles, quite similar to litigation, climate litigation more generally. And also very important, just transition litigations are not necessarily either pro or climate or anti-climate action. Instead, they just demand that climate action is undertaken in a just and inclusive way by paying better attention to those that are in vulnerable situations. And we have put this a bit more schematically on the next slide, whereby we say indeed that maybe just transition litigation should be seen as a really separate category from what has been often called in the literature pro-regulatory cases and anti-regulatory cases, whereby pro-regulatory cases would normally try to improve climate action, and anti-regulatory cases might normally be reactive against certain pro-climate regulation. But we also really clearly see that just transition litigation is not necessarily one or the other. So we say in the report, actually what we see is that they are pro-humans or pro-labor or pro-community or pro-environment. And by doing so, they may object against a transition policy that then temporarily has an anti-regulatory effect, but they are not meant to be anti-regulatory as such. And we also, for example, see that in the quotes of NGOs that bring these cases, whereby they say, we recognize that climate action is imperative, it's necessary, but it shouldn't create negative effects as we do that. I think for me, there is a final slide, which is about briefly explaining then the methods for finding and selecting the cases against this broader background. And in this sense, we have made use of several databases that are already in existence, some of which that also flag specifically just transition litigation cases, including the Sabin Center's own climate case chart. So that's what we have used, the global one. We have also thankfully made use of the database of AIDA for climate litigation, the database on Business and Human Rights Research Center, and specifically a database for the Brazilian climate litigation. And in addition to that, the report draws upon several of our own research projects, and having done also for the paper some original research into selected jurisdictions, whereby we have tried to find through database research, but also online, through internet-based research, ongoing cases, which sometimes were identified, for example, through news items, and then we snowballed or looked up further from there what these cases were about. So this is the underlying approach. And it's maybe good to say that within our selections of cases, we have at the moment mostly focused on the energy sector. So perhaps not so much the mobility or agriculture. And we have focused mostly on mitigation and not adaptation. And we may have also still missed some cases. So the research is not necessarily meant to be the exhaustive picture of any type of litigation that exists in Latin America or even in the countries that we have focused on. Although I think we feel confident that we have been quite thorough there. I think this is the moment for me to hand over to the next presenter in our group, which I think is Maria Antonia, if I'm not mistaken.
Thank you so much, Marlies. Yeah, so I'll talk a little bit about sort of the who, what, where of the cases, just a brief overview of what we found. Like Marlies said, this is not a comprehensive analysis of all of the just transition cases in Latin America. Maybe there are other cases that we did not come across yet, and this is really meant to be like a starting point to other researchers continuing this this investigation and looking into some other countries more specifically, or other regions as well. But we found 20 cases, and I think what's interesting in our research is that we obviously, just transition litigation is a very new field within climate litigation in and of itself. So we had the cases started in 2016. So we have one case in 2016 and 2017, and then two 2018, one again 2019, and then from 2020 onwards it starts picking up a little bit more. So there's a slight increase since 2020, and this really indicates how just transition litigations are growing as countries are responding to this global long-term goal of emissions reduction agreed in the Paris Agreement. And as these policies are developed, or as specific projects are engaged with by governments and other stakeholders, then this litigation, which is sort of a reaction to that, comes up to actually make those processes just and participatory and so forth. So despite this small sample of cases that we found, this increase in just transition litigation cases shows that obviously you can see from the graphic that it more than doubled in the past 3 years, showing this rising trend, which we anticipate that it's going to continue growing within the region. And in terms of sort of the where, we identified cases in 4 different Latin American jurisdictions: so Mexico, Colombia, Brazil, and Chile. And there are also 3 cases that were filed either in France or at the special procedures at the UN, but these cases relate to Mexico specifically. So there's that connection, obviously, to Latin America and what's going on there as well. But Mexico has 10 cases and Chile has 5. So you can see that obviously the numbers are a lot higher in these 2 jurisdictions, and the way that we go into detail in the report about sort of why that is, but it relates to policies. In the case of Mexico, energy policies, and there was a lot of backsliding in terms of that, of energy policies, and Mexico was significantly investing in renewable energy, but then due to a change in the legal framework, that was reversed, and because of that there are a lot of cases questioning that from that just transition perspective specifically. And in Chile it relates to I have 2 colleagues from Chile here amongst our group, so they can obviously explain this a lot better than I can, but it relates to an ambitious decarbonization policy that Chile has put forward, and certain questions related to how these decarbonization policies and projects were implemented, again, sort of focusing on that effective participation aspect of it that is part of this just transition framework that we talked about. So I wanted to just briefly talk about sort of the who and bring this slide that Marlies talked about on the actors, just as a reminder of sort of from that just transition angle, who we identified from this literature that we build on, who are the actors in just transition. So you can see that there's a wide variety of actors ranging from, workers, states, financial institutions, companies, and then future generations in nature, and civil society groups and trade unions as well. And then we try to make this link in terms of how that reflects within the plaintiffs and defendants in climate, in just transition litigation specifically. So while we started this research actually thinking that we would have more workers or trade unions as plaintiffs in those cases, what we eventually found was that that was really not the case. So the vast majority of cases were actually brought by NGOs. We have a small number of cases brought by children and youth and union workers, and then also cases brought by government agents and political parties. And sort of in the middle, there are cases brought by indigenous communities. So indigenous communities actually have a significant share of this sample of cases that we found. And then in terms of the defendants specifically, so the vast majority of cases are against government agencies, but then there are a few against private companies, public companies as well, and then both against a government agency and a private company together. So really see sort of a mix of that, but the vast majority, like it is as well within the broader scope of climate litigation as a whole, is still against government agencies too. So now we will move over to Pedro to talk about the industries.
Thank you, Maria Antonia. Well, so I will focus more on the. I will start with the categorization of cases that we made, and I will focus on the categorization by the industry involved. So, regarding the type of industry involved in climate litigation and just transition, we found 4 types of industries. So the commission of existing fossil fuel projects, mining or infrastructure of new technologies in renewable energy, and subsidies for fossil fuel projects. So basically here we saw that the majority of litigation is in new technologies and in renewable energy. But generally, if we look more closely, the different categories, there are like interesting approaches in each one. So can we move to the next slide, please? So in the case of the commissioning of existing fossil fuel projects, I think it is important to firstly acknowledge that the energy transition will lead to the closure of fossil fuel production sites, affecting workers in the sector. So here, an illustrating case is Company Workers Union of Marítima and Commercial Limited and others versus against the Chilean Ministry of Energy. Here, the affected workers of a coal mine that was closed sued the Minister of Energy, and the Chilean Supreme Court ordered the authorities to implement a plan to reinsert affected workers into the labor market and ensure a just energy transition. And this basically meant like this ensuring the just energy transition was ensuring like reconversion plans, for example, to benefit the workers. So that's a very concrete decision from a tribunal. Then if we pass to the next slides, please. Another kind of cases that we found is mining or infrastructure in new technologies. Here in the picture, you can see a field of lithium projects in the Atacama Desert in the north of Chile. So this refers to the potential field of legal conflict in lithium projects, for example, a mineral that, as we know, is vital for producing electrical products such as electric cars or batteries. So there is like a controversy here. And here there is a case where the Chilean court, the case is Atacama Community of Coya versus the Ministry of Energy and others. And here the Chilean Supreme Court granted constitutional relief to the plaintiffs and by invalidating some contracts for the exploration and exploitation of lithium awarded to foreign companies. And basically here the decision was based on the lack of a consultation process with indigenous communities involved by referring to the International Labour Organization Convention, number 169. So we think that this is another field where can be some climate litigation on just issues can be developed in the following years, especially because in South America, between Bolivia, Argentina, and Chile, we have huge or important sources of lithium. So, and then a third subcategory. If we pass to the next slide, please. We identified cases where litigation challenging the development of renewable energy projects. So this is challenging as well, and this is the largest number of cases that we found. So here a helpful case to review is the one between the Union Hidalgo against EDF, a French energy company, for the installation of a large-scale wind farm. And here the case was brought to different fronts. So the OECD national contact points in France, also the Paris District Court, and the special procedures of the UN Human Rights Council. It is interesting how the UN special procedure highlighted the due diligence aspects deeply, and here, for example, the free prior and informed consent principle. And also the applicants here raised some concerns about the energy poverty. So basically this logic that there is an installation of renewable energy projects, but basically those projects are in benefit of large companies instead of the local communities. So here we have another kind of potential conflict as well, not only because of the installation of projects, but also of who are benefited by these projects as well. And finally, if we can move to the next slide. Another type of litigation, and here maybe it's something that is also happening in other regions of the world, is related to subsidies for fossil fuel projects. Here we found an interesting case in Brazil where the plaintiffs challenged government subsidies extended to a coal complex that was built in the 60s. And I hear the plaintiffs challenge government subsidies that were based on a just energy transition program that was approved by the Brazilian government in 2022. But this just energy transition program was, in fact, what this law instituted was an economic subsidies to coal industry. So here, well, this another issue to debate, but there is like a cooptation of the term, no, of just transition, and it is interesting as well how the plaintiffs argued that this program violated the right to a healthy environment and the Paris Agreement and the commitment of Brazil, but also some procedural aspects related to the composition of the Just Energy Transition Council proposed by this law, violating the principle of participatory democracy and equality. So the plaintiffs here asked to declare this law unconstitutional. So these are the different categories related to or refer to the industry involved. And now I will pass the floor to Riccardo, I think.
Yes, thank you. Hi everyone. Well, before I start, let me thank Maria Antonia and the other colleagues who work with me on the report, the Sabin Center for organizing this webinar, and the director of AIDA, and of course the audience for being here today. Well, when we examine the legal grounds on which the selected cases are based, human rights immediately emerged as the main legal basis for these lawsuits. And this is quite intuitive, I think, quite evident, not only because of this rights turn in climate change litigation, which has been very much discussed, but also, I think, because of some specific features of just transition litigation cases. In the end, if we go back to the definition of just transition litigation that we provided in the report based on the pioneering work by Savaresi and Setzer, well, human rights are expressly mentioned there, but beyond that, reference is made to local communities, those who are most vulnerable, and so on and so forth. So what I mean is that just transition litigation cases emerge from these types of situations. Okay, so it's I think very clear and evident that human rights have and will have a primary role to play in these cases. Now, slide please. Thank you. So now diving into the section of the report where we categorize the selected cases on the basis of the rights invoked. Well, as you can see, first of all, we adopted this very, quantitative approach, as you can see by the charts with numbers, even percentages, and even if, some of us may be not really keen to this type of approach, I think that it makes sense at this stage of the research, at this initial stage of the research on this topic, as our intent was really to give a clear picture of the existent cases. The idea was to show what we have, or at least what we found so far, and then more qualitative, also prospective, if you want, analysis will certainly come. Having said this, in terms of substantive rights, as you can see, we have the right to a healthy environment, the rights of indigenous people, substantive rights of indigenous people to land and the natural resources they dispose of, labor rights, as well as in a minor component, other rights like right to health, life, and energy that play a role in the selected cases, also in combination of, often these rights are often used together, as you can see in the chart. Now, if it was obvious, as I said, that the rights-based approach was somehow prominent in just transition litigation cases, it was not at all evident, at least to me, that the right to a healthy environment played a major role here. As you can see again in the chart, in the graph, it features in the majority of the selected cases. To make it short, I would see this right as more useful to to traditional, if you want, pro-climate cases, okay, than in just transition litigation. But I would say indeed that this right has been specifically used in those cases, among the selected cases, among the cases that we examine, in those cases that aim to foster the transition, okay? So that, as we write in the report, that use just transition framing to promote more just pro-climate policies, okay? So we decided, as it was mentioned also at the beginning, to include this specific type of cases in the analysis. To give an example, the Wayuu indigenous community case in Colombia, and Natalia here is the expert on the case. And I think that, at least personally, this is one of the tricky point or controversial point of our report that, if you want, then can be discussed in the Q&A. At the same time, it was not obvious, at least to me, that labor rights, although, as it was mentioned by Marlies, decent work is a fundamental dimension of just transition, but labor rights were used in a small fraction of cases, 2 cases, but actually one main case that was the case already discussed by Pedro, company workers union of Marittima and Somarco in Chile. That is, however, a leading case. Okay. Then if you can go on with the slide, please. Thank you. And then besides, or along with substantive rights, also procedural rights play an important role in the selected cases. As you can see again by the graphs, blue means that these rights are present in the lawsuits. As you can see, they are present in a good number of cases. Actually, in the report, we included this examination within this justice angle as an expression of the principle of procedural justice that, as has been said by Marlies again, in our view, should lie, at the basis of just transition litigation. But in the end, even here, we are speaking about rights. Okay, so about the right to information, the right to participation, both in environmental context and also in a labor or decent work context, as for instance in the Chilean case that was mentioned. And then we have the free prior informed consent, the right to free prior informed consent, which is, as you might know, a specific and very important tool that is enshrined also in very important international instruments that should allow and grant the participation of indigenous communities, in particular, in the planning processes related to specific projects that affect their land. Okay, but we can also, expect that if not this right, or at least some components of these rights might be somehow extended also through pioneering strategic litigation, also to other traditional, if you want, local communities that are and will be affected by just transition projects. And with this, I'm done. I'm also saving some minutes from the time I was allocated, something that never happened, but I would save this time for the very end for another consideration, if we will have time. If not, it's not a problem. And I thank you very much for your attention, and I leave the floor to Natalia, who has been really one of the real driving forces behind the whole report. Natalia.
Thank you, Riccardo. So I will now talk briefly about the other categorization that we analyzed when we were working on this report, which refers to the climate angle. And in this particular section, we assessed how the cases that we analyzed in the report refer to this climate angle by asking whether the initial petition in each of those cases referred to long-term temperature goals based on the Paris Agreement, referred to the nationally determined contributions or NDCs, and or relate to policies and activities that are necessary to achieving decarbonization to net zero emissions, which includes renewable energy projects or mining of minerals for renewable energy technology. It should be noted that the climate angle in these cases is, in this particular last category that I mentioned, is not always as obvious as it might be in some of the other categories. At first, these cases might appear similar to like more dominant understanding of environmental rights cases or labor rights cases, but for the purposes of our research, the cases that we analyzed and included in this category are there because the projects are being pushed forward due to decarbonization policies or laws, which in turn could come in some cases or could derive in some cases from the Paris Agreement commitments. So as we can see in the chart, the figures that we have here, the petitions in each of these cases reference the Paris Agreement and decarbonization policies in the majority of these cases. And we found that this could derive or stem from the fact that all Latin American countries ratified the Paris Agreement, and there's also already in place a relatively solid decarbonization policy framework along with existing labor and environmental laws in each of these Latin American countries. As to the NDCs, although there are some cases that do refer to the NDCs in particular in this initial petition, the majority does not. And this, we believe, could be explained since not all NDCs include explicit or specific mention to just transition, which could make it even harder for plaintiffs to make the necessary connections to push forward these sort of arguments, especially given the emerging nature of just transition litigation. Next slide, please. So the mention of the Paris Agreement as well as the NDCs in these cases, we found that it is almost always used as a supporting argument towards energy transition. Since all Latin American countries have ratified the Paris Agreement, the goals to achieve carbon neutrality and to reduce greenhouse gas emissions are now part of each country's overall decarbonization policies and actions. The cases that we analyzed use the country's international commitments as a basis to ensure these just transitions, which we saw in, for example, the case of Company Workers Unions of Marítima case in Chile, the WAYU case in Colombia, Nuestros Derechos al Futuro y Medio Ambiente Sano case in Mexico, just to name a few. The same happens to the NDCs, which, as I mentioned, is also used basically to support arguments towards the energy transition. In particular, as I mentioned, not all NDCs from all countries mention just transition. Chile and Colombia does. So maybe as a result, the Chilean case that we've already mentioned explicitly invokes this, the text of Chile's updated NDC in 2020 that refers to the concept of just transition. And in this particular case, Chile is promoting the energy transition from an aspect that encompasses both a socially and environmentally sustainable economy, including job creation, social justice, and poverty eradication. So the petition in this particular case further argues that decarbonization and just transition are interdependent and that it affects all the rights of different stakeholders, including communities, workers, and businesses. Finally, regarding the decarbonization policies, we found that most of the policies adopted in each of these countries stem from the international commitments that they have acquired by means of, for example, the Paris Agreement. In this same case that I've been talking about, the plaintiffs are challenging an act that was issued as a result of a decarbonization policy adopted in Chile, and they are arguing that this act gives rights to companies over workers in the energy transition process. Claimants acknowledge the need to comply with the international commitments towards decarbonization, but they also seek that their rights as workers are included in all efforts towards such decarbonization. Furthermore, we also found that in Mexico, the Mexican electricity industrial law and its amendments have been challenged in several cases. Although there are some differences regarding specific arguments case by case, we did find a common claim regarding to the fact that these acts, as plaintiffs claim, prioritize fossil fuel projects over renewable energy. plaintiffs consider in these cases that this is endangering the energy transition and it's avoiding or preventing the country to comply with its international, regional, and national commitments in terms of greenhouse gas reduction emissions reduction, and the fight against climate change. So now Lorena will present our analysis regarding remedies.
Thank you, Natalia. I also thank AIDA and all the group because it was a very interesting process to work on this report. So in my part, I have to talk after all this project, what did we find out about success in just transition litigation? And when we try to find if those litigation were successful, it's kind of complicated to give a conclusion. Like on a first approach, we found out that with the data that we got, with the limited cases that we had, first of all, we can conclude that the cases were not a real threat to the energy transition or to the decarbonization process. But I think that if we consider this triple dimension of just transition, litigation, and all the aspects that are involved, we cannot just go so limited with the analysis, because if we start thinking what is what moves to the communities when they go to court to ask for a remedy, I'm sure that if we read the petitions, we find out that those communities are very concerned about climate change, and in most of the cases, they were very supportive with the decarbonization process. But what was happening in Latin America is like we are repeating the same problem that normally those jurisdictions face when with the traditional litigation on environmental issues. So we need to open our eyes and see that the main problem that these communities are facing is not that they are against the just energy transition. They are just asking to improve the policy, to improve the law, and to be considered in the decision-making of this process. So, for example, in the cases that are on the report, 7 of the cases were successful. What does mean? That the court, they grant the petition of the plaintiff, and the court, in most of the cases, invalidate the policy, or because they consider that it was made without proper participation, it was against the law, or it need indigenous consultation. In 2 of the cases was not successful because the petition was not granted. 6 cases were pending at the end of the 2022. 1 case was withdrawn, 1 injunction was granted, so that means that the project was stopped, and 1 injunction was denied. The project was stopped during the case, but it was not a final decision. So when we relate the success of just transition litigation also with the remedies, and we consider that what is the remedies in the context of the Latin American jurisdiction is not the same approach that we can find in the European court, because normally when we talk about remedies, we understand that are the compensation that these people, the plaintiff, will receive after they go to a court and they get their petition granted. But those compensations normally are found on the environmental impact assessments. So we were not able to find any reference to a specific compensation for these people regarding the just transition litigation. So in most of the cases, what the court says in Latin America to the government or to the companies that were involved in the litigation was stop this project, go again to a new environmental assessment, and comply with the participation or with the consultation. But the point is, like, if the Latin American context, like considering the government agency and also the courts don't really have this conscious of how are they going to make the consultation, and is the participation real? We will continue with increasing the litigation. So at the end, if we have to say, was the just transition litigation process successful in Latin America? I think the concept has to be considered with all the relevant actors here. So from one perspective, for the companies to have the access to all these cases, it made them awareness that if they don't push the government to improve their litigation, I don't think the projects will stop, but it will take more time to conclude. So that can be considered a real threat to just transition litigation. For example, if we mention the case in Mexico that finally was decided in an international court, at the end, the company withdrew the project, and that may be like something that is not really good for the population there. And that's something that probably the people there, not all of them wanted to stop the project. And other interesting case, considering the success and the remedies, is the case that most of the speakers have commented, is the Company Workers Union from the Supreme Court of Chile. And this is an interesting case for me because the court litigation has some like clear impact on the policy of the government, because the Supreme Court ordered the government to improve the policy for the decarbonization, because the government with the energy sector made this agreement to go over faster decarbonization, but the workers were left behind. So normally the government and the company say, no, we make the consultation, but the worker insists in the court and say, no, they haven't asked, what do we want, how do we want, and when do we want this? So this, even when the court granted this decision, it took a long process after the end of the past government and the new government to finally have an agreement on how the discussion was to set that. So for me, that case is also a success case because it can at certain points set the rules. How deeper the participation is what the courts are asking, like in order to comply with the international standard. The other aspect that is important to consider with all this litigation in Latin America, and sometimes not getting what the communities really want when they present the petition to the court, is like we have seen that probably some cases are going to international court. Somebody make a question about that. How do the Latin American jurisdiction is solving their cases like international in the regional system? It's not so common as in the European context, but we see, and also even after the consultation made by Chile and Colombia regarding climate change, that this is probably be a new way of solving those just transition case going to the Inter-American Court. But however, that that system asks to the petitioners to go over like the domestic court first. So the next slide, Maria, I don't know if I have. So at the end, like just repeating what I said, remedies request by plaintiff, the plaintiffs in 8 cases ask for the suspension of the policy of activity, and the court in 8 cases, they ask to the court the annulment of the policy or activity, and in a minor number, they ask for participation of affected group. So thank you, Maria, and thank you, everybody. That's part of my presentation. So now I guess, Maria, it's your time to make the conclusion.
Yes, thank you so much, Lorena. Thank you, everyone. I think this is really helpful. Just would like to invite all of the participants, if you have any questions, please put them in the Q&A. We do have a couple of minutes to answer that. If there's anything that you'd like some more information, you can, feel free to put it in the chat and we can go over it. But just as sort of a conclusion to all that was said, we the big sort of there are 5 specific conclusions that we have as part of our report. The first one is the issue of environmental and climate justice. We do have, like I said, 20 cases. A lot of those cases, like Lorena mentioned, are still pending. So there hasn't been a decision yet. And so we'll see sort of how that develops and how that's going to affect policies in general. A lot of the cases do relate to extractivism, which is, like Gladys was saying at the beginning, a core sort of aspect of Latin America and how socioeconomic development is pursued. So that contradicts at points with environmental protection and this climate rhetoric. So there obviously the region as a whole still needs to address some of those contradictions, and that is slowly being reflected in policies, but also like we are seeing in litigation as well, not only just transition litigation, but broadly on climate litigation in general. And I'll say that Natalia and I have written an article with another colleague that's going to come out, I think, probably next month about climate litigation in Latin America more broadly. So have a look at that once that's out as well. And then in terms of the social aspect of it, there are obviously, this historically, this has always happened. There are always marginalized communities that are affected by some of those extractive activities, and just transition litigation has really been proven to be sort of an avenue for them to raise their voices and actually say how they're being impacted by that, and having their specific needs and what they are legally have rights to being responded to by courts as well, and so having that being respected is a way to obviously prevent further social conflict. And I think the main message within just transition litigation is also that, like, sort of how can we learn to actually do that, do the decarbonization movement with being inclusive to the communities that are being impacted, to actually avoid further litigation. So that was sort of our main goal in looking at those cases too, was to find some of the lessons that we can learn for policies as well. And then in terms of indigenous resistant and environmental human rights defenders as well. And it's important, obviously, to again, be inclusive and have their voices be heard by that, and remaking political economies as well, and sort of rethinking those original structures too. And then finally, COVID-19 was obviously a setback in all of that, and on all of the implementation of policies, but it's also an opportunity to actually consider the specific communities that have been even more affected by than others, and then having that be part of how policies are developed as well. So, just wanted to just show the images of all of us that were part of that group. It was really an incredible collaborative process, and something, it was really a pilot project for the network to actually see how we could be able to work together in those smaller groups, and use this incredible source of information and this incredible knowledge that we have with over 100 rapporteurs now, and sort of focus that into specific smaller projects, which is something that we want to do more and more. And we hope to continue not only this just transition litigation group, but also others that we've started talking about as well. So I see that there are 2 questions here. So the first one was to Gladys, if Gladys could explain a little bit more about how just transition issues are being resolved at a regional level. Lorena talked a little bit about it, right? But maybe Gladys can say a bit more.
Yes, thank you. Thank you, Antonia, and thank you for that question. I don't want to be repetitive to what Lorena was saying, but what I think and what I was mentioning at the presentation is these transition issues in Latin America, and as you saw from the great presentation from the speakers, are legally currently addressed by national courts, such the renewable cases in Mexico, etc. We do not have regional cases as such. However, we do have the resolution 3 from 2021 from the Commission and Red Desk that I will paste the link in the chat so everyone can have it. And also, we do have the request for an advisory opinion from Chile and Colombia that was also mentioned as well. However, what I think it's important in a regional perspective is that, for example, Colombia produces a lot of coal, and this coal is bought by Chile, which invests a lot of money in that. So it promotes the production in Colombia. And now Chile is shifting, for instance, from coal to fracking. So that gas will be imported from Argentina, and that increases the impacts in Vaca Muerta and the Mapuche community. So it is very important to have this regional view, in the sense that if we bring cases to the national courts, that we should bring the cases for the one that is producing and the one that is importing. Like, we cannot have the cases as isolated cases. I will paste this link from the resolution because I think it's important, and we will keep an eye in the advisory opinion and participate. I just don't want to take a lot of time for the next question. So thank you. And let me know if the person who needs any further information, please share my email. Thank you.
Thank you so much, Gladys. There was another question on the criteria for selecting the cases. Marlies talked a little bit about that. I don't know if Marlies or anyone else wants to add a bit more.
Yes, it's a good question. Maybe I can clarify a little bit, because I realized I didn't say something about, let's say, the type of search terms we have used. So in the methodology section of the report, you will find in principle an explanation of how we have tried to identify the cases and also determine whether they should be part of the set or not. And I think a number of strategies there were important in the sense that we started with a number of these available databases and the cases that are there. Insofar that cases are already highlighted as just transition cases, or maybe come up because of the search, using the search term just transition case or just transition, it is quite obvious that they fit this bill. But I think we have also built the set through our other research methods, in the sense that we have found maybe also cases through additional research online or through our own research projects. Whereby we have searched for cases also online with the terms just transition, energy, court case, litigation, trying to figure out which type of NGOs, for example, were bringing certain cases. And then we studied those cases further. So in that sense, I think there were multiple strategies for us to identify cases. And even amongst the, let's say, the more traditional pro or anti-climate cases, it may be possible to look, in our view, to look for cases that highlight these issues that we try to show with the first figure. So do people actually raise questions of injustice or distributional issues when it comes to access to decent work or living conditions or livelihoods, access to basic services, for example, or maybe environment, and do they make a broader justice argument in relation to those issues? So I think we have, for example, set a case on workers' rights or labor rights where people are just demanding more pay or equal pay while they are working at a renewable energy plant, or let's say a windmill project. Just making a claim for better pay might not fit our bill. But if this claim for better pay is part of a wider setting for the case and really raising justice issues, it might come in view. And I think this is a question that we try to address head on in the project, because we're trying to look for these cases and get a grip on them. And this is the way that we have approach this. But I think there is some scope for, let's say, fine-tuning that, and also when you move to other sectors and maybe to climate adaptation cases. But I think this has been our approach. And if I'm missing something, I'm sure somebody else wants to add on. Yeah.
Thank you, Marlies. Lorena, do you want to follow up on that?
Yes, I just want to add something that is not on the paper, but a big obstacle that we faced when we were doing the research is because we knew that, for example, in countries from Latin America as Bolivia, for sure, they do have some issues, but we don't have data because we don't have cases, and there are reasons for that. But this opened a door for more research on those countries because Latin America is big and there are different jurisdictions, and the way how these issues are being handled maybe it's different for different reasons, the core, the knowledge, and the law. So I just want to add that if they are not here, it's countries that for sure they are facing issues, but we were not able to study them because they were not on any database, there were not cases that mentioned just transition or climate change. Mm-hmm.
And then if anyone is aware of other cases that we missed, please do send us. I can also put my email in here. The Sabin centers, obviously, we try to be as comprehensive as possible, but there are always cases that we're not really aware of. So we very much like to receive emails from people who point us out in sort of the right direction into some of them. All right, so was another question here about if we considered the effects of the war in Ukraine, putting more pressure on the region and the peoples affected. Maybe Riccardo and Marlies can talk a little bit about that. We didn't necessarily consider that, but maybe coming from Europe where that is being more reflected, the two of you can share some thoughts.
Well, we didn't consider it, meaning we didn't write or refer explicitly to the war in Ukraine in the report, also because this report was specifically dealing with another region, even if with Latin America, even if of course, I mean, the events in Ukraine will have really an international and universal, if you want, global impact on an impact on global economy. In my view, I would say that it's not something positive and good for the transition itself. I mean, that in my view, it's something that will slow down even more the transition, as we can see that many countries in Europe are diversifying its sources of fossil fuel. I mean, sources of not of renewable energy, but of gas and so on. But I mean, this is just a consideration. I don't know if Marlies wants to add something.
Yes, no, I would agree. And I think also this is a very interesting question to ask, and we may maybe see more issues or cases actually coming up arising from that context. I think maybe also because we are focusing on litigation, and litigation tends to be more of a slow process. We might not expect to see so much actual litigation since March 2022. So that could be another thing, and that counts both for Latin America and I think in the European context. But I would agree with Riccardo is that we need to keep a close eye to what extent these disruptions are actually moving countries not to jump towards renewable as the solution, but to also jump towards other fossil fuels. And I think that relates to what Gladys has been saying already as well, in the sense of using either transition fuels that are fossil fuels or using secure fuels that are fossil fuels. In my view, this actually would be an interesting category where people could jump in and try to raise issues of just transition that go beyond the more traditional anti-climate or pro-climate approach. So we may see cases, but we haven't seen them so far.
Yeah, thank you. So the other question was with respect to the countries that we chose, if there's a legal system that influences more or less the other one. And as an example, Spanish-speaking country and Portuguese-speaking country as far as litigation is concerned. maybe others can talk a little bit, but in terms of sort of generally, I don't think we have really seen that in just transition litigation yet. But in terms of like broadly in climate litigation more generally, I think, no, I don't know if necessarily the language would be an aspect. Obviously, Portuguese-speaking country would be very much more limited, and then the Spanish-speaking ones. But I think it's more about sort of whether similar legal strategies can be used. And we see, especially with the more paradigmatic cases like the Urgenda case and the Neubauer case, like I think it's more common then to see if that could, in the Shell case specifically, also in the Netherlands, there's a big movement after a big successful decision like that to see how that could be replicated in other jurisdictions. Regardless of the language, I think it more relates to sort of whether similar legal arguments could be adapted to a different legal context to see whether something similar could be reached. I don't know if anyone else wants to. Marlies, yes.
Yes, and maybe to add on there, I think what also could be a helpful or an interesting precursor to more just transition litigation is to see more just transition law. And we have seen already in this Latin American region as well that there are more just transition laws, or that the word just transition is used more in law. And we are actually working together also on another publication on this, which is dealing more both with the interaction between litigation and law. So I would personally also wonder that if we see more of these laws being adopted and these terms being more embedded in the national context, that countries may also start to look to each other for legal legislative inspiration, and maybe simultaneously also there might be some inspiration on a litigative action. But it was also rightly stressed that I think the situations in different countries are also quite peculiar. So there's maybe also some limitations there.
Natalia?
Yeah, I just wanted to also add that, like from my personal experience, I have seen how Latin American countries like talk among themselves, like sort of like through cases and through judicial bodies. So I do think there's influence within each other. I wouldn't say like there's any one particular country that influences or jurisdiction that influences one more than the other. But I also wanted to just highlight that even though we do talk about like Latin America as a region, we try to not like essentialize the different experiences of each country and the legal frameworks of each country. So this could also like maybe play some differences when it comes to using the same arguments that have been used in other countries, because like, you know, like experiences are different. There are context specific realities that might differ from one country to the other, even though like we do share some commonalities. So I just wanted to say that.
Thank you. Pedro?
Sorry, I was muted. So I just have, because there is another question afterwards about basically access to justice, but so I think it is important to highlight the fact that this is an initial categorization. So basically, that's a really important element, because that also assumes that this is an evolving situation. So an evolving issue that we will face probably in a couple of years with new elements. And those new elements can be related to, for example, new laws, as Marlies stated, but also new kind, and this is related to the last question. So new kind of instruments for accessing to justice. Now in Latin America, 13 countries are part of the Escazú agreement. So that also can modify some context in terms of how some vulnerable population can access to justice and litigate on just transition issues. So I think the international forums are also a point of connection in Latin America, or can also be in the future. And probably if we analyze the just transition litigation in 3 or 4 years, the situation of the or the categorization, even the categorization that we have proposed, can change a number of cases in people who is going to the court. So the word initial, I think, for me, is key in this study, and that's basically is for opening the door for further exploration, further analysis, and further elements that we need to ponderate in the case. So that's I wanted to say.
A very good point, Pedro. Thank you. And then the last question is if you could talk a little bit about the lawyers or law firms that took these cases. We haven't really looked into that. And then also the question continues in sort of whether they're public interest law lawyers or law firms, and why there's so few cases, if this is due to lack of access to lawyers or other issues like cost, standing, and knowledge. So we haven't really looked at who the lawyers are. In a lot of those, especially I think in the Mexican cases, they're big NGOs that are behind it. So usually they do have sort of in-house lawyers that bring those cases. Maybe Gladys can talk a little bit about that as well. And I don't know if others have any comments. Marlies, yeah.
Yes, maybe I can make one comment there that maybe does not necessarily go so specifically to the law firms, but more to the NGOs that bring these cases, maybe also with in-house legal expertise. And something that I find very interesting that we see in this Latin American report, but that I also see in my own research that focuses more on Europe and energy transition and litigation there, is that it is a very interesting cooperations often between environmental NGOs and social NGOs. And I think this is a very powerful realization in the sense that actually NGOs are teaming up on these issues. So it is not just environmental versus social. They are seeing that they are actually striving for very similar things, so that their objectives are the same. And that maybe also means that they can pool their resources, pool their knowledge, and improve their legal claims. Because as it was explained before, it's interesting to see how some of these cases actually bring up quite a bunch of different human rights together, including the right to a healthy environment along with socioeconomic rights. So for me, that is not necessarily about the type of lawyers, but more about the type of NGOs that are pushing these cases and that are actively teaming up. Yeah. And I hope to see more of that, to be honest.
Yeah, Gladys.
Yes, thank you, Maria-Antonia. Thank you, Marlies. Yes, I would say that in Latin America, the ones that are litigating most is civil society, as you were saying. And most of NGOs from the environment are also working in the human rights aspect of that, so which is key to this issue. It has been also key in these cases to have the support of law clinics, for instance, from universities, from researchers, from independent, from professors, also from in some cases from the rapporteurs that have done any positions on that. But in answering specifically to the question, I believe that these cases are brought by civil society. Those are the ones who are acting, and it's been a challenge because of the huge amount of financial and human resources that these kind of cases involves. Thank you.
Thank you, Gladys. Lorena?
Regarding the same, like, what can I say about Chilean jurisdiction and about the access to justice on these cases? It's mostly at the moment the the civil society, but there are a lack of access to justice regarding lawyers or attorney, and there are some like organizations, a domestic organization as FEMA or sometimes the Human Rights Institute that take some cases, but there are a huge demand of cases. So normally they select the cases, and there are still other communities that don't have attorneys, and normally they don't get to the court because, for example, if you go to the environmental courts, that is very technical and need like a special language and knowledge. So normally they miss the deadlines, and there are a lot of obstacles for them to litigate. And if they go in the other way with the constitutional action, Sometimes also the big companies have like strong and powerful lawyers with a lot of knowledge, and they cannot really deal with that. So there is an imbalance, but I think that after the Escazú agreement, it get really implemented in the domestic jurisdiction, maybe we can have a solution, because it will be some like modifications regarding that. Mm-hmm.
Thank you so much, Lorena. Yeah, the role of pro bono lawyers is also very important. And I think it's something that here in the United States is more institutionalized, but it's growing a lot within Latin America, I think. And obviously, there are some conflicts of interest sometimes, because these are lawyers in usually big law firms who can only take those cases when it doesn't go against their own clients' interests, right? So there are some limitations, but it's an important way in which this can further develop. All right, I think these were it for questions. Any final words from anyone? Okay, so I'd just like to say a really, really big thank you, first of all, to Lorena, Marlies, Natalia, Riccardo, and Pedro for first of all, like working on this report. It's been a really, really wonderful collaboration, and I'm really glad that we did this pilot project, and hope to continue this soon. Thank you so much, Gladys, for coming in and sharing the background and your expertise. AIDA has been truly an amazing partner, and it will be incredible to have this report in Spanish, which AIDA is translating to. And then thank you, Cami, too, for all of the logistics and for making this happen. All right, thank you all the participants, and we'll see you soon and continue this conversation. Bye, everyone.
Thank you.
Thank you so much, Cami.